Good morning, ladies and gentlemen. You could continue enjoying your pizza. I understand that pizza is for free, right?
Yes.
When I was a student, there was nothing for free, you know. It's a great benefit to have some pizza for free. My name is Vladimir Khvalei. I am a partner at Moscow office of Baker McKenzie. In addition to that, I am wearing a couple of hats. One more hat is Vice President of ICC Court of Arbitration, and also I am the Chairman of the Board of the Russian Arbitration Association. And I would like to thank Grant Hanisyan and my colleagues for inviting me to make a presentation on corruption issues in international investment arbitration. I was told that there are people who are studying here arbitration, and just for me to better understand your background, do you know what is investment arbitration? You do. Do you know the difference between investment arbitration and commercial arbitration? Who knows? Can you raise your hand? Okay, so there are some people who know what is investment arbitration, what is commercial arbitration. Okay, I'll explain you where is the main difference. Any arbitration is based on arbitration agreement. If there is no arbitration agreement, there is no arbitration. Arbitration is by consent. When you sign a contract, a private contract with your counterpart, you have arbitration agreement in the contract, and if you have a dispute under the contract, you start arbitration. That's commercial arbitration. That's commercial arbitration because it's based on arbitration agreement between two commercial entities in commercial contract. So it's a private contract and private arbitration. Investment arbitration is a little bit different world. Investment arbitration is normally based on international treaty. For example, Russia and Kazakhstan signed bilateral investment treaty. This is agreement between the states, and each state undertakes to protect investments of the investors of the other state on the territory of the hosting state. But its obligation, because this is a treaty between two states, is obligation between the states. However, in this treaty, normally state gives also unilateral offer to investors of the other state to arbitrate any dispute between investors of the other state, i.e. private entities, and the state in case there are some events related to expropriation of investments, unfair treatment, and so on and so forth. So in bilateral investment treaty between the states, you have an offer from the state to arbitrate given to the investor, and if investor is badly treated by the host state, and investor decided to protect its right by initiating arbitration, it accepts an offer, and this arbitration becomes investment arbitration. So it's an arbitration between private entity and the state based on bilateral investment treaty and not based on a private contract. Why is so important? Because there are two different sets of regulations with regard to arbitration. While private arbitration is normally based on principles laid down in your convention, European Convention on International Arbitration, and arbitration law of the place of arbitration, investment arbitration is based on international law. First of all, bilateral investment treaty or multilateral investment treaty, and various cases which were related to investment protection. Again, there's a huge debate to which extent these precedents are really precedents and are binding on arbitrators. So I'll be talking about corruption issues in international investment arbitration because they are a little bit different than in private arbitration. Why it's more interesting to talk about international investment arbitration, because the cases many cases are public, so you could read the cases and analyze it, while in commercial arbitration you very often cannot find arbitral was published. I'll start my presentation with Corruption Perception Index, which is published by Transparency International. And the yellow color highlights the countries with a low level of corruption, and the brown color or red color highlights the countries with higher level of corruption. So the more dark color is the higher level of corruption is, and we have here people from various countries. You could find your country on this map and understand what is the level of corruption in your country. Needless to say, that corruption is a huge problem because corruption and poverty are overrelated. And I would say one is the cause of the other and vice versa. What is also known because of corruption is that World Bank estimates amount of bribes paid globally as 2% of global GDP. So there's a huge amount of money which are paid as bribes. And well, needless to say that unfortunately corruption is widespread, and very often investments are made by using various corrupted means. There are various legal instruments related to combat against corruption. You have it on a slide. I will not repeat them, but because we are studying here, it's very often useful to have somewhere on a list various international instruments, so you could look into it later. But I'll be talking about how tribunals in investment arbitration normally deal with corruption allegations, because the way how it works, I'll give you an example with a famous case, Kenya with World DutyFree versus Kenya. I'll mention this case also later. The case is pretty interesting by itself. One businessman decided to build duty-free shops at Kenya airport, and in order to do it, it needed license from the government. He tried to get this license several times, he failed, and then some intermediary who used to work for administration of Kenyan president said, well, if you could make some donation to Kenyan president in amount of $2 million, then you'll get permission to open your duty-free shops. So he did. He took a big case, $2 million is actually, it's not a small case, it's a pretty big case. It will weigh around 20 kilos. Because recently there was a famous case in Russia where Ministry of Russian Economy was given a bribe of $2 million. So Russian mass media speculated how much it is in terms of weight, and they calculated that it's around 20 kilos, so it's pretty heavy weight. So he took a suitcase, as I understand, a pretty big one, and he had a meeting with Kenyan president. He left a suitcase not at his office, but before his office, where was some kind of reception desk. His secretary said he had a meeting with the president. It was very nice talk. And the president asked him what you want to do. He said, I want to open duty-free shop in your airport, so people will be traveling to Kenya and out of the Kenya. They'll have, nice presents and gifts and so forth and so forth. And so Kenyan president said, well, it's very good. We need people like you to open nice shops. So meeting went very well, and then he left, president. He took again the suitcase back with him, and he opened it in his car and found out that the case was full of corn. Corn. You eat it kind of like popcorn. So the assistant who arranged this meeting, a president assistant who arranged this meeting, said, well, it's a very good sign. It's a very good sign. It means that the president accepted the gift. And indeed, soon after that, the license was issued for opening duty-free shops, and duty-free shops operated pretty well. And then presidential campaign began in Kenya, and unfortunately this gentleman supported a wrong candidate, not the one who won later a president campaign. So the one who won president campaign was offended that the investor supported not him but the other guy, and he confiscated all his shops in Kenya airport by revoking the license. So the investor started investment case against Kenya, and during the hearing the investor testified, and during his testimony he told the story. He wanted to show how corrupted Kenya was and how he suffered because of corruption in Kenya. And it was completely new information for the respondent. And the respondent was represented by Emmanuel Gaillard, a pretty well-known name in international arbitration. And when Emmanuel Gaillard had this testimony about bribe, which was given to Kenyan president, he jumped up and said, by the way, we didn't know about it. And he made the whole case about it. He said, well, we just now discovered, and it came from the claimant itself, that in order to make investments in Kenya, investor made a bribe. Gave a bribe to the president of Kenya. And it was a legal act. It's against international public policy. There should be no any protection to such a legal act. And as a result, the tribunal dismissed the claim of Kenya. And there are a lot of cases like this one. Well, let me put it this way. In many investment arbitration cases, corruption is alleged by the state as defense. Not in every case where corruption is alleged, corruption is proven, because it's very difficult to prove. However, it raises a lot of issues. There are some legal issues, some issues related to fairness, and I'll try to touch some of them. First of all, what are the legal issues? If it is proven, let's assume that it's proven that some bribe was paid by investor to the state. What does it mean? Does it mean that tribunal has jurisdiction or does not have jurisdiction? Does it mean that the claim is admissible or not admissible? Or does it mean that the claim is admissible but should be dismissed on a merit? So there are three stages where the claim could be denied, and I'll try to briefly explain you where is the difference. Why it is the issue of jurisdiction? It's the issue of jurisdiction because investor's claim is based on bilateral investment treaty. And if bilateral investment treaty contains the wording that the investment should be made in accordance with the laws of the host state, when you pay the bribe to make investment, you breach the law while making investment. If you breach the law while making investment, means that investment was not done in accordance with bilateral investment treaty or multinational investment treaty. So tribunal normally says, look, I have jurisdiction to protect your investment only if you do investment in accordance with the treaty. If you don't do investment in accordance with your treaty, I don't have jurisdiction. So if the tribunal says I don't have jurisdiction, it means that your claim is denied because of lack of jurisdiction, and it means that investment is left without any protection, because theoretically investor could go to the state courts of host state, but normally if the state confiscates the property of investment, there's no chance to win the case in the state court. So tribunal finding that tribunal doesn't have jurisdiction means that investor is left without any protection, and the court, the state, in fact, benefits from it. Because what happened in Kenya case, the case received all duty-free shops at Kenya airport for free, as in some other cases. Some tribunals decide that it's not the issue of jurisdiction, but rather issue of admissibility of the claim. They're saying, okay, we have jurisdiction to consider dispute between investor and the host state, but the claim is not admissible. Why the claim is not admissible? Because international public law says no claim based on illegal contract is allowed. When you make a legal contract, you cannot go to court or tribunal and try to protect your right based on a legal contract. So they're saying if the contract is obtained by a bribe, it's a legal contract, your claim is inadmissible. So it's a little bit different legal qualification. The result is the same. The claim is dismissed because it's inadmissible. Some tribunals are saying, okay, we have jurisdiction, the claim is admissible, but still it should be dismissed on a merit when considering the case on a merit, again, because of illegality. But it's not, again, a main focus of my presentation. My main focus of presentation is a different one. This is something I want to discuss with you because my presentation was meant to be more for the purpose of discussion rather than simply presentation. If you look into two pretty famous cases, World Duty-Free versus Kenya, Metal Tech versus Uzbekistan, you'll see that in World Duty-Free, the investor invested $37 million. He paid $2 million as a bribe. He claimed $500 million as a loss of investments. The claim was denied. and none from the Kenyan side was prosecuted. So from one side, Kenya raised defense based on corruption. They received investment for free, and they did not prosecute the former president who received the bribe. In Metaltech versus Uzbekistan, this is a relatively recent case. The value of the project was around $20 million. $4.4 million was paid to consultants. A huge amount of money was claimed. This is also one of the, by the way, this is one of the reasons why investment arbitration is criticized today, because very often investors are seeking for compensation which is highly inflated in comparison to what they really investment. As people are saying in Kazakhstan, I'm not sure in Kyrgyzstan people say the same, that's a nice saying, if you want to have a ship, ask for a camel. So this principle unfortunately works these days in arbitration. If you want to get 5 million, claim 50 million. You'll get 5 million for sure. So the same works for international investment arbitration, unfortunately, in many cases. But again, in this case, Metaltech versus Uzbekistan, no one was prosecuted in Uzbekistan, although tribunal found that the payments which were made to consultants, I'll come back to this case, were illegal payments. I don't want to spend more time on DutyFree versus Kenya case. I already explained it a little bit. In Uzbekistan, again, the background of the case was that there were some consultants which were hired by a joint venture in Uzbekistan, and it was found that the consultants were paid not for assistance with the operation of the joint venture in Uzbekistan, but for lobbying activities. There were very high amounts paid to consultants. I mentioned already 4.4 million. No service or proof of service, lack of qualification of consultants, and lack of transparency of arrangements. And tribunal found that consultants had connections with the government because one of the consultants was a high government official whose duty were included examination candidates to head various ministries and government departments. So one of the consultants was a brother of the Prime Minister of Uzbekistan. Tribunal dismissed the claims because of lack of jurisdiction, but again, no officials were prosecuted in Uzbekistan for their involvement in the project. There's a pretty interesting statement made by tribunal in another case against Uzbekistan, I believe Centex versus Uzbekistan, where tribunal made a pretty interesting observation that corruption as a tango requires two to dance. So meaning that if it is investor who is paying the bribe, it is also a state official who is receiving the bribe. So it's not unilateral act like fraud. In a fraudulent activity, the state could be misled by the investor, but if you are talking about bribe and corruption, it normally involves activities of two sides, and very often the bribe is requested by the state. From one side, the state official could request the bribe from the investor, or insist on it, or create all possible obstacles for investors that investor could not make investments without paying bribes. From the other side, the state do not prosecute the official. And you know, for those of you who already started studying investment arbitration, you will know articles on state responsibilities. And a general principle in investment arbitration is that any state official, any state company, any state authority is deemed to be the state. And the state is responsible for actions of any state authority or any state official for the purpose of investment treaty protection. However, while normally state is responsible for actions of their officials, when it comes to responsibility for bribery, the fact that state official, like in Kenya case, the president of Kenya received a bribe, release, in fact, state from responsibility as effect of recognizing that it was illegal contract. And dismissal of investors' claims leaves the state unpunished. And more tribunals are voicing concern about some kind of unfairness of the outcome of the case. In a World Duty-Free versus Kenya, the tribunal said it remains nonetheless a highly disturbing feature in this case that the corrupt recipient of the claimant's bribe was more than an officer of the state, but its most senior officer, the Kenyan president. And that it is Kenya which is here advancing as complete defense to the claimant's claim the illegalities of its own former president. And here I want to say something about disproportionality which we see today in investment arbitration cases. If you look, for example, on OECD Convention on combating bribery, OECD Convention is saying that in case of bribery, the state should confiscate the bribe and proceeds of bribery. So basically what the principle of OECD Convention is, if there is bribe and proceeds from a bribe, you must confiscate it. But OECD Convention does not say that you should confiscate everything, all property of those who are involved in bribery. Like in case of robbery, you know, I'm not protecting the one who is involved in robbery, but in case of robbery, you do not normally confiscate all property of the one who committed a crime. You could punish the individual, you could put him or her in jail, but you do not confiscate the all property. If you look further into Council of Europe Criminal Law Convention on Corruption, it also says it imposes on a state to introduce proportionate criminal or non-criminal sanctions, including monetary sanctions. So again, Criminal Law Convention on Corruption also talking about proportional responsibility. If you look into laws of various states, you will see that in some countries, like UK, you have unlimited fine in case this is responsibility of legal entities, not individuals, because legal entities could also be liable for paying a bribe. So in some countries you have, like in UK and Canada, an unlimited fine by the law on legal entities, but in some countries, like France, you have a fine up to 5 million or 2 times the proceeds of the offense. United States, it is more complicated system of fines. In the Netherlands, in Sweden, you also have fine, but the fine is limited. In CCSI regulation, it is stated about disgorgement. Disgorgement means transfer of illegally received profit. And when calculated, the illegally derived profit, CCSI regulation says that the cost should be reduced when you calculate the disgorgement amount. So the point I'm trying to make here is, I'm not, of course, protecting corruption or bribery. This is not the point. Of course, corruption and bribery is illegal. But from other side, what we see as a result of imposing on investors this liability by denying access to protection is that the state, which is also involved in corruptive activity, actually benefits from the principles which exist today in international investment protection. And in a certain sense, it encourages the state to continue to operate in the same way. So the state could say, okay, if investors come to me, I could request the bribe from investor, then I could confiscate everything what investor invested in my country, then I come to investment arbitration with my defense saying, okay, the investor paid to me bribes, therefore there is no protection for investment, so I'll take everything what was invested and walk away without any responsibility. This system seems a little bit unbalanced in terms of remedies for investor and for the state. And what's happening today, and I want to provide you some example of cases where tribunals seeing this unbalance, trying to order some other remedies in order to find an appropriate, as I said, balance between responsibility investor and the state. In a case, Vienna Hotel versus Egypt, the state alleged that Vienna was retaining the service of the Egyptian entity chairman, Mr. Kandil, under consultancy agreement, and made a significant payment, and it was at a time when some tender was conducted in Egypt. And what tribunal stated that the state's role in the corruption could serve as a ground for precluding the success of corruption defense because the state was aware of the chairman's role as advisor to the investor, and there was no proof of his conviction or prosecution. So the tribunal from one side dismissed the claim, from other side made a statement that the Egyptian government was made aware of this agreement, but decided not to prosecute Mr. Kandil, and the tribunal selected to immunize Egypt from liability. There's also another case, Spentex versus Uzbekistan, where tribunal found, based on red flags, corruption, excessive amount of payments, lack of relevant experience, and so on and so forth. And this was actually the case where corruption was denied by both parties, by the investor and by the state, and the tribunal found it by its own initiative, so sponte. And tribunal found that investment was obtained through corruption and found by majority the claim to be inadmissible. And tribunal relied on international public policy and unclean hands doctrine, but despite dismissing of the claim, the tribunal decided that legal costs should be shared. The cost of arbitration should be shared between the parties, and tribunal made a very unusual, very unusual for an international investment cases decision, and recommended the state to make donation of $8 million to UN anti-corruption fund. And tribunal stated that if Uzbekistan would not make donation of $8 million to UN anti-corruption fund within 90 days, tribunal will make a cost order with regard to legal costs and order Uzbekistan 75% of the claimant fees, which were around $17 million US. I try to find, this case is not for public. There are some articles about this case where I got this information because I was interested who was able to bill $17 million US. Didn't find out, unfortunately. But coming from, this is the most interesting case, of course, for us in this case. But apart from that, it is very unusual decision. And there are a lot of arguments whether the tribunal had jurisdiction to make such kind of recommendation to Uzbekistan to make donation. I also don't know whether Uzbekistan actually made this donation to UN fund, but what the case demonstrates is that these days tribunals are trying to find a balance between responsibility of investor and responsibility of the state. And what we saw in the cases which I demonstrated, sometimes tribunals are saying that you cannot rely on corruption defense if you do not prosecute your own officials. Tribunal could make different allocation of costs, like in Metal Tech versus Uzbekistan, and could adopt other creative measures, like in Centex versus Uzbekistan. This is all for introduction. We could talk a lot about corruption issues generally, investment arbitration in particular. I sent to the university also 2 my articles on corruption issues. One is related to identifying issues of corruption in arbitration, another about burden of proof in corruption cases. If you're interested, I'm sure you could find it somewhere on the website of university.
Posted on the CCSI website.
They are posted.
They are posted.
Yeah.
Okay, and I open for questions and discussions.
If you have a question, we'll urge you just put your hand up and then either scream or speak into the mic. We're broadcasting this, right? Yeah.
Well,
Scream.
Okay.
So for now, we don't have any explicitly solution to this issue. So some arbitrators say this one, some another.
Here's the difference with commercial arbitration, because if you do, if you have a contract which is obtained by the brand with the government, for example, you have a contract with the government for construction of road. You sign it, you put, for example, a CC clause, you paid the bride, but you build the road, but the government did not pay for the road. If you start arbitration and government would prove that the contract is illegal because you paid the bribe, you are not without protection. What you could do, you could still claim costs, because a consequence of illegality of the contract is restitution. It means that both sides should return to the other side what the party received from the contract. Because the government could not return back the road to the contractor, the government has to pay the cost, not the profit, but the cost, but still investor in such case is with protection, because it could pay cost, not profit from the contract. And normally tendency in arbitration today is for broad interpretation of arbitration clause, meaning that arbitration clause covers not only contractual claims but also non-contractual claims, like unjust enrichment in this case, related to the same contract. In investment arbitration, the consequence is different. If you make the same claims under investment treaty, and you say, well, the employer or the state confiscated what I did as investor, and the state would prove that the contract was obtained by illegal means, so the tribunal would deny any claim, and the investor is left without any protection, which does not preclude, of course, investor from starting contractual claim against the state. But sometimes you don't have this remedy, because either there's no arbitration clause, and you have to go to state courts, or by some other reason. And you're absolutely right. I mean, why I choose this topic, because there's no solution today in international investment arbitration how to deal with such situation, how to provide more balanced solution. Maybe it's for you as a younger generation to propose such solution, and maybe some of you will write theses on this issue and propose something.
Please do that. Any other questions? Yes.
So some free trade agreements now include...
Could you get a little louder if possible?
So some FTAs now have specific anti-bribery and corruption chapters. And I guess that's in part trying to address this issue as well as others. Do you think that is a potential solution, including those rules on anti-bribery and corruption in trade agreements, as well as ISDS provisions?
Well, first of all, I don't believe that that some of the agreements, they do have legality requirements, some of them do not make real difference. Because today it's well known and well accepted that bribery is against international public policy. So even if it's not directly spelled out in the agreement, in BAT, that investment should be done in accordance with the law of the whole state, still tribunal would say, well, it is either explicit or implicit obligation of the investor to act in accordance with the law. Again, technical difference could be that if it's in the agreement, it's lack of jurisdiction, it's not in agreement, it's non-admissible, but the result is the same.
Yes.
What if a tribunal would overcome all these obstacles and come to a decision on the merits? It could happen. I don't think so. But if it happens, I mean, what could be a remedy available to the state in order, to challenge this decision, you violated international law, or you went against all this.
You mean if the tribunal would order compensation despite of allegation of corruption, if tribunal, for example, finds that allegation of corruption were not proven? Well, first of all, it's not easy to enforce international investment awards against the state, because from one side it's assumed that award, it really depends whether it's award based on the exit convention, it's based on answer trial, what is the legal instrument and procedure which was used against the state, because there are different ways for enforcement. If it's done, for example, in the framework of exit convention, then you could put some pressure on the state, because exit in the framework of World Bank could put some pressure on the government, and as a result, government would have to pay. If it's answer trial arbitration, even based on investment treaty, like for example UCAS award, as you know, the major award in the history of investment arbitration, it was based on answer trial rules. So although the legal basis is Energy Charter Treaty, but to enforce UCAS award, you need to go after state based on the New York Convention. And the problem, of course, with this is that either you go to the state courts in the host state where you have no chances to win, or you try to find assets of state outside of the country which is free of any diplomatic protection, which is very difficult to find. So it's in some sense deadlock situation. So coming back to your question, if tribunal finds that there is no corruption, but investor would go to the host state court, as the state of enforcement could still refuse to enforce if the state court comes to a different conclusion with regard to corruption. For example, there's a criminal case and it was proven that bribe was paid. Or, for example, a good example is Siemens versus Argentina, because you know that there were a lot of investment cases which were brought by Siemens against Argentina, and a huge amounts were awarded to Siemens. And after the amounts were awarded to Siemens, as you know, Siemens made a serious disclosure that it paid bribes around the world. I don't know to which extent you are familiar with the story. It's a very interesting story, because Siemens, you know, like any other German company, they're very accurate in putting every number. So they have special accounts and they recorded every bribe which they paid around the world. So it's not a joke, that's what happened. And then, because of some investigations, Siemens decided to disclose this information to General Prosecutor's Office in Germany, and there was investigation in the United States against Siemens. So they disclosed every bribe which they paid in every country, including Argentina. And Siemens made a declaration that they are not going to enforce awards against Argentina because investments were made by using illegal means. So sometimes you could have consequences like this one.
We had a question here and then one here.
Yes. What do you think about the proposal made by the tribunal in context in terms of future treaty drafting? So what it actually proposed was that in case of corruption, the claim should go on, and the tribunal should go on to the merit stage and potentially find whether or not the state agrees the treaty. But if it finds a breach, it would not award damages to the investor, but similarly to what it is made with the cost orders, order the state to pay it in a fund against corruption. Do you think that's something that would be a good solution in terms of
well, frankly speaking, I believe the solution which we have in a private relations, which we can find in any country around the world, restitution and disgorgement of profit is the right one. Meaning that, this is my personal view, investors should be compensated the cost and not profit, and of course the bribe and proceeds from the bribe should be confiscated and go, I don't know where to go, maybe to the fund. Of course both parties should be penalized, not only the side which is giving bribe and the other party which is accepting the bribe, but there's no legal basis for it. I mean, we are speculating how it will be what we could do in Syria, but still, I mean, there was dissenting opinion in the Syntax versus Uzbekistan case by British Sam, where she stated that she doesn't believe the tribunal has authority to order the state to make this payment. So, this, as I said, there's no solution today.
There's a question here.
Yeah, so if you're, let's say you're advising the state, you're speaking to your client, did you ever advise them to not break off the corruption defense?
Of course, I will advise them to do. I mean, the first question we normally ask, was there any issue that the investment was made by using illegal means? Because this is one of the best defenses to the state.
So even with this changing framework, which sometimes tribunals...
Well, the cases I showed to you, southern exception. The southern exception. What is true, indeed, is very difficult to prove, and as you know, indeed, the states are very reluctant often to prosecute their officials, because their officials could still be in power, or their relatives could be in power, so they do not want to raise it. And this is why, in the cases which are quoted, either the tribunal findings on corruption came from the claimant, or by circumstantial evidence, not from the state. It was interesting, I talked at one of the conferences with the counsel who represented Kenya in this particular case, because if one reads the Kenya, one would say, well, what's a stupid counsel? Who did it? Who allowed his witness to say that he paid the bribe to Kenyan president, because one could expect such kind of conclusion from the tribunal, because it was not the first case where the claim was denied because of corruption. And he told me that the real issue for the claimant in this case and for this investor was not whether they're going to win or lose the case. They want to bring this issue, to make it public, the issue that former Kenyan president took a bribe, and because they wanted to create some publicity for whatever political purposes, they decided that the best way to do it is to voice the story at the hearing. But the negative consequence, of course, was that this statement was immediately picked up by the respondent counsel, and he made a case based on it.
Yeah. Yes, too, we go there, and I think then we can probably call it quits.
Thank you for a very fascinating talk. Can I ask you whether to push back on you on this idea that the restitution would be the ideal solution in these types of cases? Wouldn't you say that the best incentive against corruption is precisely the fact that an investor in this position knows that they're gambling not only the profits that they would lose if the investment is come to be corrupt, but also the investment they invested themselves? And you could say that cases like these send messages to investors not to invest in countries where the only way to invest is through corruption.
Yes and no. Yes, indeed, because the message is pretty strong. If you make bribery payment, there's no protection. From the other side, I don't know whether you study criminal law here. You could also make the same message, for example, for robbers. If somebody takes a mobile phone and you kill immediately this person on the street, it will send a very strong message to everyone. You know, don't do it, because otherwise we will be killed immediately on the street. But there is a principle in criminal law, principle of proportionality. The punishment should be measurable to the gravity of the offense you commit. So my point is that these days the responsibility of investor is disproportional, because it doesn't really matter how much do you pay. Assuming that somebody would build this building, right, and then because they have some problems with local fire guard, and they're saying, well, the doors are not in accordance with the law, the stairs are not in accordance with the law, we are closing the buildings, and you're paying, some small bribes to people who are responsible for public security, and then it's known that you paid some bribes, or for example, to getting construction permit. You have a nice design, you could build nice building, but people who are responsible for approving the design project are demanding the bribe, and you pay whatever, $10,000 US, $20,000 US, you build the building for 50 million, and then what? There's no protection because you paid 10,000? Do you believe it's proportional? I don't think so. I mean, of course, this is why I provided, the bribes which I mentioned here are pretty huge because 2 million, 4 million are significant amount of bribes. But if you make some smaller payment, and just remember the map which I showed you as the first slide. This is a reality. We could admit it or not admit it, but this is a reality that corruption, unfortunately, is widespread in many, many countries. Many business people are forced to pay the bribes because
please, nobody's forced to invest anywhere. They do it because they want to earn money. So, you could just say this is a cost for them earning even more money. They're not
you're saying like Karl Marx. You know that Karl Marx, I believe in his Capital, he says there is no crime in the world which capitalists would not commit for 300% profit. But believe me, because we are working with many business people, sometimes they're making legitimate payment, and then state starts to put pressure on them because of various alleged violations like environment violations, safety regulation, and so on and so forth. And they are at the choice either to close business and walk out from the country with nothing, or they have to make some donation to some people. They're in sometimes a very difficult situation. And I'm not saying that bribery is good. This is not what I'm saying. The bribery should be punished. But what I am saying is that we are now in a situation when the party who are requesting the bribery payment also get some bonus as investment itself for free. Nice incentive for them to do it.
Take the last question.
Great, thanks so much for coming. So my question is, in the cases that you've surveyed where tribunals do award some restitution or remedies for investors despite the corruption, what bodies of law do they look to when they choose the restitution? Do they look more to specific punitive measures, or do they only stay with the balance?
Frankly speaking, I cannot recollect right now investment cases where restitution was ordered. Restitution was mentioned in World DutyFree versus Kenya. I think it is mentioned in some of the paragraphs that the investors still is left with restitution claim, which of course is rather theoretical option. Restitution is the option which is available in commercial arbitration. In commercial arbitration, if it's an approval that the contract is illegal as a result of bribery payments, still you could have restitution claim, but not in investment arbitration. This is my point. In commercial arbitration, normally jurisdiction of the tribunal is broad. It covers contractual claims and non-contractual claims, including restitution. Well, investment arbitration, tribunal is saying, well, because our authority covers only legitimate claims, legitimate investments. If the investments are not legitimate, we don't have jurisdiction.
But in the case that they do find jurisdiction and they still give sorts of restitution, do the tribunals just kind of make up appropriate remedy, or do they actually root their analysis on this is what the international standards are?
Well, what I said, I couldn't recollect right now the cases where they did it. Maybe for future, some of them will do.
Thank you very much, Vladimir. May I invite everyone to give a Columbia vote of thanks to you. It's taken a very long flight to get here, so we really appreciate that. And just for everyone, we are trying to focus on some of the most unsettled area. We heard that in our last talk, the hearing that today. I really do encourage everyone who's looking for topics, and there are many of you from the emails that I'm getting. This is one of those such topics. There is no answer. We have these different approaches. So think about it. So thank you very much, Vladimir. You're helping us by giving them good topics.
Okay. You're welcome.
If anyone has a few questions, he's a big guy. you'll probably not get to see him in such an easy circumstance. So meet him, talk to him, give him your resume. Thank you, Vladimir. Thank you very much.
Thank you.